Today, we're going to talk about Micron Technology Incorporated versus Rambus, a case decided by the United States Court of Appeals for the Federal Circuit, and the opinion issued just a week ago today. This case came up from the District Court for the District of Delaware, Judge Robinson. Judge Robinson held that Rambus' spoliation of evidence had prejudiced Micron, and she sanctioned Rambus by holding its patents to be unenforceable. And so Rambus filed this appeal. So what is spoliation? Spoliation is the destruction or significant alteration of evidence, or the failure to preserve property for another's use as evidence in pending or reasonably foreseeable litigation. Spoliation occurs when a party has intentionally or negligently breached its duty to preserve potentially discoverable evidence. A sanction is appropriate for spoliation that prejudices the other party or threatens the integrity of the judicial process. The key point that we're going to look at today is when is litigation reasonably foreseeable. This is not the only point of importance in the case, but it is the primary one. The important elements of spoliation, therefore, are a duty to preserve, also a breach of the duty, and also prejudice to the opposing party. The court said that when litigation is reasonably foreseeable is a flexible, fact-specific standard that allows a district court to exercise the discretion necessary to confront the myriad factual situations inherent in the spoliation inquiry. In other words, no bright-line rule from the Federal Circuit. Looking further, we see that the Federal Circuit gives us the little bit of help that the standard is not so inflexible as to require that litigation be imminent or probable without significant contingencies, as Rambus suggests. There's actually a lot that can be said about the facts in the case. In the early 90s, Rambus was a member of a standards group that related to semiconductor memory devices. And during this time, Rambus representatives to the group passed information from meetings of the group to Rambus's outside patent prosecution counsel because they wanted to obtain patent claims that would cover SDRAM. Rambus' invention was known as RDRAM. It was a way of solving the memory bottleneck that was present at the time. SDRAM was a different approach, but Rambus thought that its patents could be expanded to include SDRAM. They hired a gentleman named Joel Karp as vice president for intellectual property in October of 1997 so as to get their IP strategy in order. And just a few months later, their CEO directed the VP of IP to develop a strategy for licensing and litigation. The next month, Vice President met with outside counsel who said that the rates that Rambus was looking for, which was 5% royalty rates, would definitely result in litigation instead of licensing. And he also advised them to put in place a document retention policy. March of '98, Vice President presented a licensing and litigation strategy to the board of directors. It was not adopted at that time, but this strategy was presented. In May of 1998, Rambus started keeping its email backups for only 3 months, whereas before it apparently kept all of them. So in July of 1998, they destroyed all but one of over 1,000 email backup tapes. The one they kept was one that helped them establish a priority date. In July of 1998, the finished document retention policy was presented to the Rambus employees. October of '98, the vice president advised Rambus executives that he was planning to assert their patents against SDRAM makers in the first quarter of 2000. They had a shred day, September of 1998, to implement their document retention policy. November of '98, Rambus executives had an off-site strategy meeting, and the meeting notes showed that they planned litigation. December of 1998, a memo from the Vice President describing how they would file a suit against Intel and others in the event Intel started moving away from RDRAM towards SDRAM. April of '99, the Vice President instructed outside patent counsel to implement the document retention policy, meaning that prosecution files were expunged of a lot of information at that time. In June of 1999, the first patent that's in suit issued. Now this is kind of an important point. Rambus didn't have the patent that they were planning to assert until June of 1999. They planned on launching their suit in October of 1999. July of 1999, outside counsel prepared a timeline for proposed patent infringement suits, with October 1 later on that year as a target date. August 26, 1999, another shred party. September of 1999 was the first time the Board of Directors approved the Vice President's licensing and litigation strategy. November, negotiations with Hitachi break down, and so in December, Rambus initiates a litigation hold. Turning back to the Federal Circuit's opinion, they indicate that after carefully reviewing the record, the District Court determined that litigation was reasonably foreseeable no later than December 1998, when their Vice President for IP had articulated a time frame and a motive for implementation of the Rambus litigation strategy. The date of December 1998 might seem reasonably charitable when you look at the entire history. One of the things that Rambus's counsel pointed out during oral arguments was that the Board of Directors had not really approved any licensing or litigation until September 24th, 1999. While this is certainly an important point to keep in mind, the Vice President for Intellectual Property didn't necessarily speak for the company on all matters, and you could consider that there was no litigation strategy that the company as a whole had undertaken until the Board of Directors actually approved it. Anyway, let's take a look back at the opinion and see what points the Federal Circuit found as they looked through this. In the end, the Federal Circuit agreed that the exact date at which litigation was reasonably foreseeable was not critical. The real question was whether litigation was reasonably foreseeable before the second shred day. The Federal Circuit found 5 reasons to agree with the court below. The first one relates to document retention policies. Here they pointed out a lot of businesses have document retention policies adopted with benign business purposes in mind. They mention this in order to draw a distinction with what Rambus did. The Federal Circuit agreed that the District Court properly concluded that the entire reason for being of Rambus's document retention policy was merely to further Rambus's litigation strategy and frustrate the fact-finding efforts of parties adverse to Rambus. Business purpose, therefore, does not include preparing for litigation, at least in this context. Second, Rambus was on notice of potentially infringing activities by particular manufacturers. So, Rambus, being the patent holder and knowing of potentially infringing activities by others, would now have some reasonable foreseeability as to a litigation occurring. The knowledge of likely infringing activity by particular parties makes litigation more objectively likely to occur, because the patentee is then more likely to bring suit. So if you know of infringing activity or likely infringing activity, your litigation is more foreseeable. Now there is some curious language here about once the patent issued, the gun was loaded. A patent perhaps does constitute a loaded gun once you get it. The third point is that Rambus took several steps in furtherance of litigation prior to its second shredding party on August 26, 1999. Several steps may be a little bit of an understatement, but at least the Federal Circuit is animated by the fact that Rambus had prioritized defendants and forums, had gone ahead and created claim charts, and determined the timeline for litigation, so certainly in fact that they had a particular start date that the Federal Circuit found interesting enough to quote right here. Here's the fourth of the 5 points, and it bears reading. We don't see a lot of citations here or references to particular things that Rambus did, so you can understand this to apply to pretty much everybody. Rambus is the plaintiff patentee, and its decision whether to litigate or not was the determining factor in whether or not litigation would in fact ensue. So if you're the patentee, it'll be more reasonably foreseeable for you that litigation is coming than for the defendant. And here's the fifth point. Rambus had said that the relationship they had with the manufacturers made it less likely that they would want to go and sue the manufacturers. So the duty to preserve shouldn't have been one that inured to Rambus as early as it did, because they didn't really know until negotiations broke down at the very end that they would be suing these manufacturers upon whom they would be depending to produce their RDRAM chips. Well, the Federal Circuit points out, in general, when parties have a business relationship that is mutually beneficial, that ultimately turns sour, that the litigation will be less foreseeable than litigation that results from a relationship that is not mutually beneficial or is naturally adversarial. The conclusion with regard to spoliation is that it's not really one thing or another that the Federal Circuit found to be an indication of reasonable foreseeability, but based on the totality of the circumstances, they could not disagree with the district court, so they affirmed the district court's determination that Rambus did destroy documents when it had a duty to preserve them, and thus engaged in spoliation. Now, the Federal Circuit does go on to consider whether or not this spoliation was sanctionable. The spoliation being sanctionable only if it is something that caused prejudice to the opposing party. And they do find that prejudice was caused, and another important issue they confront is whether or not the sanction, the case-ending sanction of finding the patents unenforceable, was the appropriate sanction. And the Federal Circuit goes on to remand the case back to Judge Robinson, because it can't really tell from the record if she carried out the detailed analysis that's necessary to actually impose this most serious sanction. And there are a couple other interesting points about this case, but the main one that is going to stick with the litigation bar is whether or not something's reasonably foreseeable. So here are a couple of takeaways from this case. I'm sure there are others, but at least these are ones that should command your attention. Litigation is more foreseeable if you are the patent owner or the aggressor. Litigation is more foreseeable if you have an adversarial relationship with some other entity. Document retention programs have to be undertaken for sound business reasons other than preparation for litigation. Finally, a litigation hold should be placed if you're drafting claim charts as the patent owner, because remember, a patent is now a loaded gun. The mere possession of a loaded gun may not be enough to make litigation foreseeable, but if you're pointing it at anybody, litigation becomes much more likely to be reasonably foreseeable at that point. Thank you for joining us. I hope that you'll feel free to contact us if you have any questions on this or any other topic related to intellectual property law.